What does this impeachment of President Trump actually do? What does it require? When Speaker Pelosi formally gavelled in these two House votes impeaching Trump, it triggers a constitutional requirement for the Senate. Begin a trial of the president, and there's no debate about that requirement.
Well, under the Senate rules, we're required to take it up if the House does go down that path, and we'll follow the Senate rules.
The trial of Donald Trump will define him in history and provide a framework for Americans to assess evidence of his conduct heading into this campaign. No other president has ever run for office after impeachment because no other president got themselves impeached this quickly. So this matters, and the battling has already begun over how to run the trial. Senate leaders jousting over these past examples. But there are very few precedents because there's only been, as you've heard by now, 2 presidential trials in all of history. So right now, we turn to one of the most momentous special reports we've done here. What do the rules require when the president's put on trial? And how does it go down? Well, the answer differs from most government proceedings. We're about to walk you through some amazing examples and footage. The trial of the president basically has 3 layers. The first is the Constitution, which has ironclad rules for the trial and a high bar for kicking presidents out of office. Now, that's set in stone, totally unchangeable. The second layer are the current Senate rules, originally passed in 1986, that provide how the trial runs. When you hear senators say what the rules require, they're usually talking about these rules. And then there's the third layer. And that's where the Senate just makes up new rules as it goes along, which is different than every other trial in America and different than every other day in Congress. So other than those requirements I mentioned in the Constitution, the Senate can actually change most of the trial rules with a bare majority of just 51 votes. You can think of this as the jazz layer, where senators can go full Miles Davis and improvise throughout the trial as long as they have 50 other senators willing to jam with them. Now, more on that in a moment. But now we begin, like America, with the Constitution, which grants the power to charge, to impeach, to the House. So only the Congress, the House, may impeach. In Bill Clinton's case, top Republican impeachment manager Henry Hyde formally presented the articles.
I hereby deliver these articles of impeachment.
That's what it looks like. I hereby deliver them. And the Constitution says when the House does that, the Senate shall try the case. And it must replace the usual presiding officer, currently Vice President Mike Pence, with the Chief Justice of the Supreme Court. So we know what that looks like. During the Clinton era, it was William Rehnquist, who walked across the street from the relative obscurity of the Supreme Court into the Senate floor. He was originally nominated by another president forced out under the threat of impeachment, Richard Nixon.
Do you solemnly swear that in all things appertaining to the trial of the impeachment of William Jefferson Clinton, President of the United States, now pending, you will do impartial justice according to the Constitution and laws, so help you God?
There he was, signing in the senators. Trump's trial will be presided over by Chief Justice John Roberts, a conservative who's known for sometimes breaking with Republicans on political matters. The Constitution lists the supermajority requirement to convict a president, and it limits the president's power. So Trump cannot pardon impeachment cases. He can't pardon himself if he were convicted. But that's about it for that constitutional layer. The rest of this turns on the Senate rules, which tee up a public indignity for any impeached president. Just like any other defendant facing legal problems, an officer of the law brings the president a formal summons. So while Trump saw this news like everyone else, we know from history a summons is still headed to his White House.
Tonight, as the Sergeant at Arms arrived at the White House with a summons, formally notifying the impeached president that he is now on trial, Mr. Clinton's lawyer said the White House is confident President Clinton will not be convicted.
You saw for Clinton, the summons coming by that SUV. For Andrew Johnson, when he faced trial, the summons was actually hand-delivered to the White House. These same Senate rules lay out how the Senate can deal with any problems. They can actually provide prison time enforced by the Sergeant at Arms for people who disrupt or talk during the trial.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against William Jefferson Clinton.
senators don't get to talk either. Because this is a trial and the senators are sort of transformed into jurors, that explains it. You don't see jurors stand up and give speeches at trials. So like them, if the senators have a question, they have to submit it reduced to writing. And then the Chief Justice handles it. So Americans will see a judge quoting the senators for any questions or points they want to raise.
The Senate has provided up to 16 hours during which senators may submit questions in writing. This question is from Senators Thompson and Snowe to the House managers, from Senators Schumer and Kerry of Nebraska.
An impeachment trial is one of the most consequential things the Senate does, and the Senate does get a kind of a makeover. For Clinton, there were carpenters in the Congress's cabinet shop that made new impeachment tables for the trial that could fit up to 15 lawyers sitting in the well of the Senate. Right now, Trump White House counsel Pat Cipollone expected to lead the legal team, but a 15-person table could leave plenty of room for anyone else, including TV lawyers, if they add any. Now, as these lawyers and House managers battle it out, the rules give the first call to the Chief Justice, but unlike a courtroom, the Senate jurors have the final call. Now, sometimes the judge can lead and his call will hold. Most of our footage tonight is from the one televised impeachment trial, but take an example from the 1868 trial of President Johnson. The Chief Justice ruled about senators deliberating behind closed doors. 130 years later, we found Chief Justice Rehnquist cited that precedent for ruling on an open trial until senators closed the door to deliberate.
And Chief Justice Chase, in the Andrew Johnson trial, stated in response to an inquiry, there can be no deliberation unless the doors are closed.
Senators can follow those leads, and there may be topics where they'd rather not weigh in at all. But the senators can also override any evidence call a Chief Justice makes with the bare majority. And history shows on the big calls, the rules give way to that other layer I'm telling you about, the improvisational jamming, with senators making up rules and plans as they go along. And like Miles Davis, they are often miles ahead of the Chief Justice, which was on display at the Clinton trial when a younger version of Senators Biden and McConnell touted their initial bipartisan plan for how to start the trial, knowing they could still jam out and change the rules later.
We believe that unless we remain bipartisan, the public is not going to conclude we were fair.
Well, this is one of the great days in the history of the United States Senate. We came together 100-0 behind a procedure to handle what will be remembered as the trial of the century.
You're not dreaming. That is a real Mitch McConnell touting bipartisanship. And it was striking, but I'm trying to make sure we all understand that was just at the start. Once both sides were presenting their cases, the brawling began. A Democratic elder, Senator Robert Byrd, moved to try to cut the trial short after the opening arguments by calling for a vote to dismiss the articles.
Robert Byrd, one of the senior statesmen of the Senate, caught everyone by surprise when he announced late this afternoon he would move to have the trial dismissed.
Continuing the Senate trial, he said in a statement, quote, will only prolong and deepen the divisive, bitter, and polarizing effect that this sorry affair has visited upon our nation.
Now, that Clinton case had gone on far longer than the Ukraine probe. Years of investigation by the independent prosecutor. All potential witnesses had testified under oath, many several times. So Democrats were arguing it was time to end it, while Republicans pressed to add witnesses to the Senate trial.
Republican House managers told the Senate they have a witness list, finally, naming names. President Clinton's friend Vernon Jordan, White House aide Sidney Blumenthal, and Monica Lewinsky.
The Senate laid down the law today. House prosecutors can persuade the Senate to call witnesses, but only a few, and only if they can add to the case to convict the president.
And in contrast to what today's Republicans are saying right now, at the time, those congressional Republicans backed adding those witnesses to the trial.
You never called any witnesses in the House. Why are you insisting on witnesses in the Senate?
Well, that's an important distinction. The threshold in the House was whether or not there was enough evidence to submit it to the Senate for a trial. We were acting like a grand jury. We didn't feel it was necessary to parade witnesses in. Now, Having impeached the president, it's over in the Senate where the trial, this is a trial, not a grand jury proceeding, not a probable cause hearing. And we have a tremendous burden.
The idea of not being able to call witnesses is crucial. How would you like to do this show without guests? What if you sat here and read transcripts based on questions you ask? Your ratings would go down.
How would you like to do it without witnesses? That is Mr. Graham, then a House manager, now a senator. But this is also where the rules matter, because the Constitution requires a Senate trial, but not of any particular length. The Senate rules govern how witnesses can be used, but not whether there are witnesses. The Senate can make those decisions as the trial goes. In the Clinton case, the Senate voted to both continue the trial and add those 3 witnesses.
There were 2 critical votes today, and the Republicans held all of their members in line. Votes to dismiss the trial and to subpoena witnesses. Here's how the votes went. On the motion to dismiss, no 56, yes 44. On the motion to subpoena witnesses, the mirror image, yes 56, no 44.
Republicans won that vote on evidence. They added the new witness interviews, and they had Lewinsky, Jordan, Blumenthal. So keep that in mind as the Senate preps this Trump trial, because 51 votes can change the rules any time. The trial can start without witnesses and add them later, or start with a plan for witnesses and then vote not to hear them. And senators can get votes on all of this. That's what Senator Schumer is talking about when he says that no matter how this kicks off, they can get later votes on specific Trump witnesses.
I will ask during the impeachment proceeding for a vote on whether Mulvaney should testify and whether Bolton should testify. Any Republican thinks that they can escape having to vote on this no matter how quickly Mitch McConnell tries to truncate the trial, doesn't know the rules.
Doesn't know the rules. And McConnell knows them. He was talking about them and how they apply to this very issue of witnesses back in 1999.
Well, under the rules that we adopted in the 1860s to deal with impeachment trials, it would take 51 votes to call a witness unless 2/3 of the Senate agreed to do otherwise.
Fact check. True. If Republicans unite around, say, avoiding any witnesses, and McConnell can hold that line, they can do that. But if at any time 4 senators in the Republican side say, hey, wait, maybe we should hear from John Bolton or Rudy Giuliani, they can go do that in the middle of the trial. Now, back in 1999, check this out. It was Senator Susan Collins championing how more witnesses would serve the search for truth.
I need witnesses and further evidence to guide me to the right destination, to get to the truth.
Do witnesses get to the truth? Well, senators will have a chance to answer that on the record. And while you may hear, even tonight, some observers covering this and talking about it as if these standoffs are going to be resolved in one moment or one day by Mitch McConnell or when the trial starts, what you now know from this rules breakdown is that's not really the whole story. When you grasp the rules, you grasp that most of them can change any time. McConnell could start the trial planning for no witnesses, and then in the middle, a vote could add a witness or 5 or 10. Again, it's whatever the 51 senators decide to jam out on during the trial. And senators may still be making up their minds in real time. The whole country tends to watch and make up their minds on these things. The trial of a president is so much larger than any other story we ever come here and talk to you about. That's a dynamic we also saw in the reaction to the last trial in 1999, a different era with different media and also some familiar faces.
You've been extremely tough on the president for his personal indiscretions, and yet this morning you have high praise for him. Is that right?
Well, I used to think I was crazy about Clinton having a split screen view with a guy, but yesterday's polls show that 8 out of 10 Americans think he's been a highly successful president, and 8 out of 10 Americans don't trust him. I guess that's where I'm at.
Do you think they scored any points with these tapes today? Call us at 1-888-MSNBC-USA and join our chat room at chat.msnbc.com.
Much has changed since then, our politics, our platforms, our media, but the Constitution has not. It still provides that unshakable foundation to this process. The House charges. The Senate holds the trial out in the open so the public can see. No person is above the law, especially not the person holding the temporary power to, as the Constitution says, take care that the laws be faithfully executed. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.